Good afternoon. Welcome to the Dhronas IAS. We are here with a special session on right to die or right to die with dignity. You must have heard that Supreme Court has recently pronounced an historical judgment on right to die with dignity, and we will try to look, or rather we will try to analyze what are the challenges, what were the important cases regarding right to die with dignity, and in which cases Supreme Court has produced which verdict. We will see all these things, right? So let's start with the right to die and right to die with dignity. This particular concept, since India under Article 21, India has right to life, it is automatically a question that whether right to life also includes right to die. And throughout the last 50-60 years of judiciary, there are many cases which actually ask this question, whether right to life includes right to die or not. So we'll try to see all those cases. We'll try to see what are the judgments and all. Achha. So, as I told you earlier, why this particular topic is in news? Because the Supreme Court has recently passed a historic judgment. Supreme Court has recently passed a historic judgment on passive euthanasia. On passive euthanasia. And the case, I think, for those of you who are watching this video, I think you have already have read the news that the removal of a life support of a 30-year-old man who was in permanent vegetative state for more than a decade. It's unfortunate that he had that accident 13 years back, and presently the Supreme Court has allowed the removal of the life support, right? And why this judgment is so historic? Because it's not for the legal rigor, it's also for the profound humanity and empathy that Supreme Court has shown. The bench of J.B. Pardiwala and Justice J.B. Pardiwala and Justice K.V. Vishwanathan has shown, because they have quoted Shakespeare, to be or not to be, and that's the main question ultimately, to be or not to be, and the decision making in that case is very, very tough, right? Achha. So we'll see what are the other cases that we had. So let's try to understand what is passive euthanasia. What is passive euthanasia? Passive euthanasia, as Supreme Court defined it in the Aruna Shanbaug case, it is the intentional withdrawal or withholding of life-sustaining medical treatment. So suppose somebody is suffering from permanent vegetative state due to some accident, due to some unfortunate events that occurred. So if he or she is undergoing life-sustaining medical treatment, and if it can be withdrawn intentionally, then it is known as passive euthanasia, and it is actually allowed. But obviously, with some legal safeguard is there. Obviously, there are some procedural safeguards that Supreme Court has provided. But ultimately, passive euthanasia is allowed, and this underlying terminal condition, only for underlying terminal condition. That means the patient, there is no chance, almost no chance of recovering. In such cases only, the Supreme Court allows passive euthanasia after having all the legal and medical safeguards that can be possible, right? At the same time, active euthanasia is not allowed in India. Active euthanasia means deliberate administration of a lethal substance or external force such as injection or maybe suicide, these things are not at all allowed in India. It was not allowed under IPC, it was not allowed even in the recent BNS 2023, right? So it is strictly illegal. So passive euthanasia is allowed where the only for terminal patients who are not coming back. Active euthanasia is not allowed, right? Acha. Now let's check on the jurisprudential evolution of Article 21. The jurisprudential evolution of Article 21, that means since this article talks about right to life, this article talks about right to life, right to liberty, and all the other rights that are available under right to life. For example, right to privacy, right to marry, right to sleep, right to go outside India. All these, since all these are under Article 21, obviously right to die also will have to be discussed under Article 21. So if I can see that from the very famous Rathinam case in 1994 to Giancor case in 1996 to Aruna Shanbaug, the landmark case in 2011 to Common Cause 2018, which finally gave the verdict or gave the legal procedure about euthanasia, passive euthanasia, and then the present one, the Harish Rana case, which is the first instance in Indian judicial history where the Supreme Court allowed passive euthanasia judicially, right? So these 5 cases or these 5 landmark judgments are the precursor, are the actual like situations where judiciary was judiciary faced the questions of life and death. Judiciary faced the questions of what to give, whether I give right to die, whether I give right to die with dignity or not, these kind of questions, right? So, and this entire journey from say 1994 to 2026, or this entire journey actually helped Article 21 to evolve, and Article 21 to evolve to more and more about life and its complexities and its ever-changingness, right? So the first one, that is the initial debates about these 2 cases, P. Rathinam and Giancor. In the P. Rathinam case, Supreme Court actually declared Section 309 of the IPC as unconstitutional because this actually criminalized attempt to suicide. But Supreme Court at that time, Supreme Court actually took provisions of other articles to interpret Article 21. Supreme Court interpreted Article 19. In Article 19, all of you know that Article 19 talks about freedom of speech, right to speech. It also includes right not to speak, right? So same way, Supreme Court said, since Article 19 has right to speech and right not to speak, Article 21 should include right to live and right not to live. Right not to live. Just a minute. Okay. So right to live and right not to live. Article 21 should include that, and Supreme Court said that, and that's why Supreme Court decriminalized the attempt to suicide, Section 309 of IPC, and Supreme Court commented that punishing a person who is already driven to the brink of despair is inherently cruel. Obviously, Supreme Court realized that when a person attempts a thing like suicide, he or she is already in the brink of despair, and at that point, if we punish that person, it is inherently cruel. So what Supreme Court did? Supreme Court struck down Section 309. But obviously, this 1994 judgment was very short-lived because in 1996, in the Giancor case, In the Giancor case, Supreme Court said right to live does not include right to die. Does not include, and it was a 5-judge constitutional bench. It's a 5-judge constitutional bench. They actually overruled the judgment. And why they overruled? Because they realized that life, right to life, it's a natural right. It's a natural right, that's why it cannot be suspended. Then how can we ensure, how can we give right to die as a right? And that's why the preservation and the protection of human existence is important. So no right to die. So Supreme Court actually overruled this judgment, and Supreme Court actually said right to life does not include right to die. But yes, in this case, Giancor case, Supreme Court actually said that right to die with dignity can be considered for those special cases, for those terminal unfortunate people who are suffering terminal diseases, who are suffering from inexcusable pain. Right. Achha. So that was the initial debate in 1994 and 1996. Now later on, we had the catalyst, we had the major case regarding right to die, and that is Aruna Shanbaug. The history of this case is very, very sad. Aruna Shanbaug, a nurse in King Edward Memorial Hospital, she was a nurse there, and she was attacked. She was sexually assaulted. She was brutally sexually assaulted by a janitor there, and she went to permanent vegetative state that we commonly call coma. She went to permanent vegetative state, and she was there for 37 years before the first petition. And in this 37 years, she was taken care of by that hospital's workers without any care in the world, without any expectation or reward. They actually took care of her because she was one of their own. Her own family abandoned, but they stayed. And that's why when a journalist filed a case as the next kin, you can file a case as the next kin to remove the medical treatment, to remove the medical support that she was getting. The hospital workers objected, and Supreme Court actually realized that, and Supreme Court actually did not give right to die in that case. Supreme Court officially recognized and legalized, however, the concept of passive euthanasia. Even though in this case the right to die was not established, Supreme Court actually recognized passive euthanasia. But Supreme Court did not give that to the Aruna Shanbaug, and there were some legal safeguards also implemented. It was criticized for those legal safeguards only. The legal safeguards were like you have to have a judicial magistrate sign your petition. There has to be 2 medical boards. So all these are very time-taking, and all these are highly procedural in nature, and it will take much time, right? And it will only prolong the suffering of the patient. And that's why the judgment was heavily criticized, even though it officially recognized and legalized passive euthanasia for the first time. And that was the catalyst. Aruna Shanbaug later died of natural cause in 2015. But this was one of the catalyst case that started again the discussion on right to die with dignity. Because if I live with dignity, I should have right to die with dignity. And the logic of all the arguments in favor of right to die with dignity was that my bodily autonomy, and I have my bodily autonomy, and I should have right to stop any advanced medical treatment that I have been getting. Right. Achha. So that was Aruna Shanbaug 2011. Next we have the final case, and that is Common Cause NGO versus Union of India 2018. The Common Cause NGO, a registered NGO, they filed a case, and that time Supreme Court verdict definitely declared that the right to die with dignity is a part of Article 21. So this particular case, the Common Cause NGO versus Union of India, that actually made sure that right to die with dignity is a part of Article 21, and it's an intrinsic fundamental facet of the right to life guaranteed. Right. So right to life includes right to die with dignity, but when, again, with some legal and medical safeguards, otherwise it can be heavily misused, right? So what Supreme Court operated here? Supreme Court first time legalized the execution of living wills. Living will, like, it's a medical directive. Suppose any person can have a living will, that if, God forbid, if that person is ever put under such a situation, if that person is ever suffering from life-threatening disease, or maybe he or she is suffering from a terminal disease, not coming back, not recovering, in such cases he or she should have the right to stop any medical treatment, and that is living will, advance medical directives, right? But the thing is, this 2018 rule, actually said that the AMD to be countersigned by a judicial magistrate of first class. Again, the procedural delays, okay, and the actual withdrawal of treatment will require the dual medical board. That means two medical boards, right? So see, these things, these legal safeguards, these are good actually, no doubt about it. But the thing is, it actually delays the process. It actually, lengthens. It actually elongates the suffering. Nothing else, right? So that's why 2023, in 2023, Supreme Court intervened and Supreme Court again modified. So what was the modification? The first change was magistrate requirement was removed. No, we don't need. You can do it, but notary public also, or a gazetted officer, right? That will be very easy to get. Second is medical board. The timing of medical boards should be accelerated, so that we don't want to prolong the suffering. We want to have a swift end, right? Acha. And finally, the board composition. The original rules had a very strict rule for the board composition, but now it's a very simplified rule composition, that you can have more practical for standard hospital environment, because the first one was more idealistic. This one is more practical. So we have the 2023 changes, right? And that makes the entire process a bit easier to execute. And then finally, in March 2026, the month that we are in, we have the historic verdict. In the Harish Rana case, the Supreme Court finally recognized that clinically assisted nutrition and hydration, CANH, via PEG tubes or any medical equipment can be entirely called as medical treatment and not merely as basic care. Because when this family, the family of Harish Rana, when they actually appealed to Delhi High Court, they actually rejected the petition, because they said it's not a medical treatment that you will have to cut off. It's a basic care. They appealed to Supreme Court also. Supreme Court first time rejected their petition. They appealed again, because they said the family, the old parents of Harish Rana, and they were having huge financial trouble as well as obvious mental and physical trouble, right? No parents would want that their young son, a topper in Punjab University, has been suffering, has been lying like a dead person for 13 years. No parent would want that, right? And that's why they appealed, so that his life can be taken away. And it will not be a it will be a mixed emotion for them. Obviously they will be sad, but they will also be happy, in that sense that that boy is not suffering anymore, right? So Supreme Court, that's why Supreme Court replaced the colloquial term passive euthanasia with precise legal nomenclature, withdrawing or withholding of medical treatment. And Supreme Court reclassified this particular process, clinically assisted nutrition and hydration, as medical treatment rather than basic care. And this reclassification helped in what? This reclassification helped in withholding that, because now it can be done, because now it's the medical treatment, right? So Supreme Court did that. And also in this entire process, Supreme Court's judges, the two judges bench, J.B. Pardiwala and K.V. Viswanathan, they quote Shakespeare, they quote philosophical quotations, because ultimately it's a matter of life and death. It's a matter of, and just imagine the situation: a parent is demanding death for their own children. It's a huge burden. It's a hugely sad moment, and that's why Supreme Court said that the entire courtroom became very sad while listening to all those arguments. And also Supreme Court quoted that Supreme Court praised the family that they did not abandon Harish Rana. Aruna Shanbaug was abandoned by her own family. This case they did not abandon, even after suffering huge financial pressure, even after suffering obvious mental and physical pressure. They did not abandon. They only appealed after prolonged suffering. Right. Achha. So, as to quote our ex-CJI D.Y. Chandrachud, while he quoted that in 2018 Common Cause judgment, the death represents the culmination, dying is the process. And Supreme Court's this verdict, this historic verdict, will help actually ease the process a bit. Death is obviously it's ultimate reality of life, but dying is the process. And Supreme Court's verdict in this case, it has to be philosophical. So for UPSC perspective, in ethics paper, you have to deal with this situation definitely, right? So from ethical perspective also, you can use this, that dying is a process. And Supreme Court, this verdict will help in easing the process a bit, will help in those countless people who may be suffering from terminal diseases, right? Achha. So finally, thank you for this session, and I hope कि right to die with dignity under Article 21 is now firmly established, and Supreme Court's this verdict will help those countless voiceless patients who are now suffering from life-threatening or maybe life-taking diseases, and they are not coming back. Maybe for them now it's the way to have right to die with dignity, and now is the time maybe to remove or to stop the medical treatments because they are not working and they are simply in the permanent vegetative state. And it will also end the suffering of their loved ones, because nobody wants to see one's loved ones in pain, right? So in that case, this particular section has importance. If I talk about UPSC now, this particular section has importance in both polity, society, as well as obviously in GS4, that is ethics. With that, thank you, take care, and we will again come back with more such nuanced topic. Thank you, take care.